Welcome, everybody, to our weekly Cyber Policy Center workshop. We are thrilled and honored to have with us today Professor Eugene Volokh of, I'd say, UCLA Law School, which is still true, but also a visiting fellow here at Hoover, soon to be a permanent fellow here at Hoover. So he will be joining us here at Stanford in short order. Actually, I mean, he's joined us already, but will be fully ensconced next year, and we're really thrilled to have him. Professor Volokh is the leading expert on so many aspects of American law, principally, two very important amendments, the first and the second. I'd put him as the leading expert in American law schools these days on those. He's one of the most widely cited law professors, not just of his generation, but literally all time, and has written influential scholarship on so many areas of free speech law, and also started the Journal of Free Speech Law. He was, I remember even when I was a law student here, he started what was then and continues to be one of the most influential law professor blogs, the Volokh Conspiracy, now housed at Reason. But he is really one of the most prolific legal academics in the country today. And today he's going to be talking about his paper, Large Libel Models. It is one of a series of pieces that he's written on sort of looking at First Amendment issues and tech. And so we are thrilled to welcome him permanently to Silicon Valley and thrilled that he can be here today to present his paper. Thank you, Eugene.
Thank you very much. It is always a pleasure to talk about this subject. It's always a pleasure to talk at Stanford, so it's a double pleasure, pleasure squared. So the first draft of this article was written around March of last year, where there were no AI libel cases pending. But it was pretty clear they were coming. And in fact, they have come. There are two. One of them is pending in the Federal District Court in Maryland, another in State Trial Court of all places for interesting procedural reasons in Georgia. And in fact, OpenAI's motion to dismiss was just denied 2 weeks ago in the Georgia case. So this is a thing. It's happening. And the question is, what should we think about it? I should also add it's happening as to libel, and much of the talk is going to be about libel, partly because that fits better. Large libel models, large invasion of privacy models just doesn't sound as good. Doesn't fit the acronym, but also partly because I do think that this is the bulk of the problem, but there are also going to be similar problems with possible negligence claims based on potential, like let's say negligent, allegedly negligent instructions that lead to physical harm and the like. So let me start with the output that led to Battle v. Microsoft, the Maryland case. Jeffrey Battle, it's Jeffrey with an E-R-Y, also known as the aerospace professor, is this, and that. He honorably discharged U.S. Air Force veteran. However, Battle was sentenced to 18 years in prison after pleading guilty to seditious conspiracy and levying war against the United States. So it turns out that everything up until the basically Bachelor of Science degrees is accurate. Everything starting with the phrase Battle was sentenced is itself also literally accurate by itself. So either of those two outputs, either everything up to science degrees or everything starting with Battle was sentenced, would be completely correct. The libel here, if it is a libel, is in the word however. And it is in the first word following however, which is battle. And of course, that's because there are two battles. There's Jeffrey Battle with an E-R-Y, and there's Jeffrey Battle, R-E-Y. Jeffrey Battle is the aerospace professor. Jeffrey Battle is the person who I think he tried to join Al-Qaeda shortly after September 11th. The error here is in linking the two together, is in the word however, which suggests that what precedes it and what follows it are connected in the sense of being about the same person. And as I said, the word battle, because in this kind of context, the convention is if you just use the last name, you're referring to the person whom you had just written about. So the question is, does Battle have a good claim? Now, as it happens, Battle is self-represented, and I don't think particularly well self-represented. He may lose for that reason as well as various others. I will say one thing that he has going for him is he says that he had actually informed Microsoft several times about this happening, and they told him, "Oh, we're looking into it and such," but they never actually fixed it. So they're on notice. We'll see to what extent that is relevant. They're on notice of what's going on. They, of course, being Microsoft, not being the AI. Just to make clear, nowhere am I saying you can sue the AI. Maybe one day you might be able to, who knows. But today, no. These are lawsuits over output by AIs, but of course the lawsuit is against the company that operates it. All right, why is the clicker not, oh, okay, there it is. Huh, am I pointing in the wrong direction? No. It just doesn't seem very sensitive. Okay, so here's the other case. Actually, I'm sorry. I originally said Middle District of Georgia because it had been removed to Federal District Court in Georgia. It's now been remanded. This should have said Georgia Superior Court. So the user says, can you read this file? And ChatGPT at this point is 3.5 says, yes, I can read the document you provided. It's a legal complaint filed by Alan Gottlieb against Mark Walters, who's accused of defrauding and embezzling funds from the SAF, the Second Amendment Foundation. Plaintiff seeks recovery of misappropriated funds, this and that. So this turns out to be even more broadly inaccurate in that the lawsuit is not against Mark Walters, not against any Mark Walters, anybody named Mark or Walters. It is not about embezzlement. The underlying complaint is brought by the Second Amendment Foundation. It is a challenge to a gun control law that was enacted by the Washington legislature. Where Mark Walters comes into this, where talk of embezzlement comes into this, well, there's a reason somewhere in the algorithm, somewhere, probably Walters, who is himself a not infrequent commentator, has commented on the Second Amendment, so maybe there's some association based on the collocation of the words in the model between Second Amendment and Walters. And maybe he had written before about some case involving embezzlement, so maybe that's why at one point the words defrauding and embezzling come after Walters. Other than that, this is just all false, just all false, false, false. And the question is, what does the legal system say about that? I'm still having trouble with the clicker. Okay, all right, so before we get into the analysis of those lawsuits, or more broadly of lawsuits against OpenAI, against Google over Bard and the like, let me start with a hypothetical analogy. Let's say there's a program called CheckBKG for background. And it is created by a hypothetical company called Open Records. And its job is to basically do a background check on someone based on court records. Provides a list of the criminal and civil cases in which the person has been found liable, including quotes from relevant court records. Let's say that that is what that program does. And let's say it uses AI technology, whatever that might mean. It may use a large language model, may use something else. The legal system doesn't have a separate rule for AI technology, obviously, which obviates the need to answer the ever-pressing and unanswered question of what is AI, right? Computer people will tell you, AI is more or less things we haven't really found out quite exactly how to do yet, at least with a traditional algorithm. Used to be classic example of AI was chess playing programs. I think today people wouldn't call it that. But in any event, we don't need to. The legal system doesn't need to ask, is this done for using AI or not? What the question is, just simply whether under standard principles of tort law, CheckBKG would be liable. Now let's assume CheckBKG acknowledges the information may be erroneous, has a warning saying, warning, sometimes the information we are going to output is not accurate. But it also touts how good a job CheckBKG generally does compared to ordinary humans. And I do think that's important. Every so often when I talk about it, less so now than a year ago, but when I talked about this, people would say, oh, that's ridiculous. Obviously, you can't sue OpenAI. It's obviously just kind of all made up stuff. It's like you wouldn't sue over output of a Magic 8-ball or over people picking tiles at random from a Scrabble set. But I do think it matters that OpenAI is promoting itself and getting in tens of billions of dollars in investment as something that does provide something more than the output of a Magic 8-ball, right? And it's when you see something like Bing and basically Google search, both Microsoft search and Google search, incorporating essentially GPT and Google Bard respectively, to the point where people millions of times probably a day, maybe many more than millions of times, I forget what it takes to switch to that mode, when they enter something they get this output. You know, that's the kind of thing we're talking about, not just something that is marketed as a toy, but something that's marketed as a potentially useful source of information, as with my hypothetical CheckBKG. Someone uses CheckBKG to search for Joe Schmo and gets a response that Schmo was convicted of child molestation and was found liable for sexual harassment. So how would we analyze that? So first, is Open Records publishing this information? Under standard rules of libel law, absolutely. Now, it may not be publishing it in the sense of printing it in one particular fixed format, fixed in the sense of it's the same for everybody, and then distributing it in thousands of copies or hundreds of thousands of copies the way a book or newspaper may be distributed. It's distributing it essentially one to one person at a time. Maybe even just to one person. Maybe only one person has ever tried to look up Joe Schmo on this database or using this software. But that doesn't matter for libel law purposes. For libel law purposes, publication involves communication to one person other than the person defamed. That is well settled. There's not much controversy in libel law circles about that. Classic example of libel, after all, is a job reference, right? If I call up Nate and ask Nate, what did you think of Joe Schmo when he worked for you? And Nate says, oh, Schmo stole money from petty cash. That could be the basis of actually, let's say it's an email, not a call, just to make it libel, not slander, although the rules end up being not that different there. That is a classic example of publication for libel law purposes. All right, so it's publishing information, it's false, and it's potentially reputation damaging. Oops, sorry, I guess I should be using this, not the keyboard. Does it matter that it's through a computer program? I don't think it matters at all that it's through a computer program. People are responsible for not just what they say, but also for what they cause to be said. If you write a computer program that produces certain kind of output, you're going to be liable for that. Just to give another analogy on top of the analogy, let's say I get hit by Tesla driving in self-driving mode. And I sue Tesla, and they say, no, we didn't hit you. Our car hit you. Our software is the one that caused it. I say, really? You wrote the software, right? You're responsible for the actions that the software undertakes. And you may not be strictly liable for them. You may be only liable on kind of a negligence theory, or in product liability terms, it would be a design defect theory that your design was unreasonably dangerous. I'm not saying you're absolutely liable, but you are potentially liable for what this product that you let loose in the world is doing. Okay, so it doesn't matter that it's through a computer program. What about 47 USC section 230? 47 USC section 230 would give CheckBKG immunity if the problem is that there's some underlying court record that's mistaken. If the court record says Schmo is guilty of child molestation, and it turns out that he wasn't, they misrecorded the nature of the charge or some such, then in that case, 47 U.S.C. 230 would make check BKG immune. As it happens, the fair report privilege would probably too, but we don't need to detour into that. Section 230 would protect it. But if what happens is the court record correctly says Joe Schmo was convicted of speeding, and somehow the software takes that and renders it, because of some large language model type algorithm, as he was guilty of child molestation, then it's not being sued for material provided by another. Remember, that's the Section 230 language. It's being sued for material that's being provided by itself. So I don't think there'd be any Section 230 protection there. What about the notation that the information may be erroneous? Is that enough to avoid liability? The answer is no. Now, just to make clear, notations might matter. Let's say the notation is, this information is erroneous. Why would they note that? Imagine it's fiction. Imagine there's something that is a fictional account of the life of Joe Schmo. Joe Schmo is a famous person, but somebody decides to put out some fictionalization of his life story. And it's perfectly clear to everybody it's fictional. I oversimplify here, but generally speaking, there'd be no liability there because reasonable readers would not perceive that as asserting a false statement or asserting a statement of fact at all, because it's fictional. But simply noting that information may be erroneous, that's not the same. And one analogy here that we can use to a very well settled area of libel law has to do with rumor, right? If you want to look at something where there's almost a disclaimer that it may be erroneous, it's when somebody says, "Oh, I heard this rumor that," right? It doesn't say that. It doesn't say, "and it may be erroneous." But the very word rumor conveys the message that this is something that the person passing it along is not confident in. If we know something is true, we don't say rumor has it. We say it's true. But if you say, rumor has it that Volokh has been stealing from petty cash, well, that's not going to immunize you against libel liability if it turns out the statement is false, and even more so if it turns out that actually there isn't even such a rumor in the first place. Libel law recognizes that even when the reader is on notice of the possibility there may be a mistake, spreading information even with that kind of disclaimer that turns out to be false and reputation damaging is indeed libelous. Okay. I do not understand what's going on here. Huh. Does anybody?
Just use the up and down arrows on the computer.
Oh, you think? I'll try that. Okay.
No, Ben, just use the clicker. That just might have a delay on the screen on your laptop.
Huh.
It's showing up over here.
Oh, it is.
Yeah.
Oh, so you guys, that must have been odd. Here, I'm claiming that it
You
isn't
gotta
working.
Preview the rest of the talk, though.
All right. Okay. Well, so let's see.
But I think you have to point it at the, yeah.
Oh, that might be the problem. I was pointing in the wrong direction.
No, I think you have to point at the machine.
Okay.
Talk.
You've done.
All right.
There we go.
So, let's say, and I'm sorry, I should be Schmo. Let's say that Schmo informs informs Open Records that this is happening, and they don't fix that. At that point, they have actual knowledge that their software is out doing false things. But even if he doesn't inform them of that, you could at least imagine a negligent design theory. He could say, well, wait a minute, you designed your software in this way that foreseeably produces these kinds of false statements. There's a reasonable alternative design you could have used that would have avoided that or diminished that risk. Therefore, you're liable, essentially, on a negligent libel theory. All right, so That is open records in CheckBKG, and my claim is that structurally, OpenAI and ChatGPT and Google and Bard are in exactly the same position. They don't have Section 230 immunity. Again, remember it says that there's no provider shall be treated as a publisher of information provided by another information content provider. Well, they're being sued for information provided by them. The publication requirement is satisfied because publication is just communication to one other than the person defamed. If you want an example, another analogy to think about why the fact that the material being inserted by an algorithm rather than a human shouldn't matter, is imagine an algorithm that retrieves photos to match crime blotter stories. But its negligent design routinely yields the wrong photo. Absent the algorithm, this would be a clear potential libel case. And I say potential simply because there has to be a showing of negligence, for example, in a typical such situation. There are a bunch of these cases out there where some newspaper published the wrong person's photo with some crime story. And everybody says, oh, Walter Smith, I see in the news you've been convicted of this crime. No, no, no. Or arrested for this crime. No, no, no. It's a different Walter Smith. They just got the wrong photo. They got a photo of me. That is potentially libel. Well, imagine it's done by algorithm rather than by a human being going and trying to find the photo. I just don't think that that's going to get the newspaper or the algorithm designer off the hook. As I said, the inadequacy of disclaimers is pretty well settled by the analogy to rumor. In fact, if you look at the restatement of torts, for those who are not lawyers, restatement is not a statute, but it is a very influential summary of the law put out by an organization, American Law Institute, that consists of judges, professors, and lawyers. It's been adopted by courts in many states. And it actually goes so far as to say that even if you expressly state that you don't believe the statement you're repeating is true, you could still be liable, even if you specifically say it's false. I'm not sure that's right, but again, simply the disclaimer that it might be false is not enough. Okay, you might say, all right, what about the First Amendment? And I do think, and Mark Lemley and I, together with a third co-author, published an article where we argue that generally AI output should be seen as equally protected by the First Amendment as the output of a newspaper or a book publisher or anybody else. But that doesn't mean it's more protected by the First Amendment. Libel law does exist as an exception to the First Amendment, subject to proper First Amendment constraints. So if indeed there's a showing of knowing falsehood, or reckless falsehood, it's quite clear that if the falsehood is potentially defamatory, the First Amendment does not protect it against the libel claim. And if it's about a private figure, then it is generally, there's a possibility of libel liability simply on a negligence theory and not just a recklessness or knowing falsehood. So we do think that even though it's not the direct product of a human mind, it's valuable to readers. It contributes to the search for truth and such. It lets readers gather information like cameras can. It's also shaped by AI companies' design and trading decisions. So we do think it's potentially constitutionally protected, but again, subject to the normal First Amendment exceptions, such as for defamation. Yes?
What would you say potentially about a state-of-the-art defense?
We'll get to that. We'll get to that.
We do questions afterwards.
All right. So, knowing or reckless falsehood, we know, is a possible basis for liability. So, say OpenAI is informed that GPT is falsely accusing some other person, not Joe Schmo, but it's a different one, different hypo, of embezzlement. Does it become liable if it allows GPT to continue doing this? I think the answer is yes, just as if you're a reporter and you write a story about me and it makes a false allegation, maybe you're off the hook because you didn't know it was false. You don't have the requisite actual malice. But if I call you and tell you the story is false and you keep writing the same thing later, well, at that point, you do have such knowledge. And likewise, I think the company could have such knowledge. Again, remember, that was Battle's claim about Microsoft. So one possible consequence might be something like a notice and blocking requirement. Not quite notice and takedown, because you don't really have takedown as such as to AI output, but you might say that AI developers have to come up with some software that once they're alerted that this particular statement about this particular person is false, they need to block it from being regenerated. So what will end up happening, presumably, is they'll have a database where there's a list of names and a list of things about them that the software has output that prove to be false, and then they would have to have some sort of probably post-processing. It doesn't have to be integral to the large language model. Maybe you can't implement this blocking as part of the large language model, but the program doesn't have to be just the large language model analysis. It could have a post-processor that says, did we just generate one of these known list of one of these false statements that on a known list of false statements? And if so, well, then we should be out. What about negligence? So I think the closest analogy here, and it's only an analogy, it's not directly applicable here, but I do think it's a close analogy, given that negligence is a possible theory of defamation liability, is to design defect liability, which is also a negligence-based cause of action. Some people label it strict product liability, but it's really not, because a product is defective when there's a reasonable alternative design. That's why it's a negligence inquiry. It doesn't say it's defective anytime it causes harm. There's always the risk of some harm, even with the best designed of products. But if there's a reasonable alternative design that could reduce the foreseeable risks, then in that case there would be indeed a design defect liability, and I think likewise tort liability for defamation. So what are possible alternative designs? One which would not help with Walters and Battle, but might help us to many other examples that I include in my paper, is at the very least, if you output something in quotes, check the quotes. One of the interesting things about the large language models, at least when I try them, excuse me, let me be specific, GPT, although actually I've seen the same thing in BARD, so maybe it is LLMs generally, is they seem to treat quotation marks as just another token to be output. Without recognizing that to human beings, quotation marks are usually, I oversimplify here, but usually a signal that's whatever is between them is actually in some source. Maybe an unreliable source, but at least in some source, other than the fevered imagination of the LLM, right? So that may in fact be itself a negligent design. The reasonable alternative design is to at least check the quotes against the training data. And if the training data is unavailable, maybe check it against the web or something like that. And if you can't find them, then maybe you shouldn't be outputting them as quotes. Another possibility is just to avoid generating quotes. If you know that you can't assure that what is between quotation marks actually appears in some source. Again, forget about assuring that it's correct in the sense the underlying source is correct. If you can't even assure that it ever appeared in any source any human being ever wrote, then maybe you shouldn't be outputting quotation marks. Now that could still leave open a lot of other possible libelous statements, such as in the cases that I mentioned, but at least it would diminish in some respects the possible damage caused by the libel, precisely because, as courts recognize, quotations are especially damaging to reputation because of the claim some other authoritative source says that. Another possibility is double-checking the output. I've noticed that sometimes you ask ChatGPT something and it says, and then you ask again, are you sure? And they say, oh no, I'm sorry, I've erred. Well, if it could check the second time, maybe it should check that automatically. And maybe there's some sort of mechanism also to try to determine whether the material that's being included that's being output is especially likely to be libelous. Now, to be sure, all of these are non-trivial coding exercises, and some of them may, in fact, potentially likely to be libelous. How do you figure that out? You can't figure it out with perfect accuracy, but how do you figure out even with relative accuracy? The thing is, they are in the coding business, right? And they have created these really remarkably powerful tools. So to say, oh, yes, we can output grammatically correct and plausible sounding output based on all of these trillions, quadrillions of bytes of data, whatever, But checking quotes, ooh, that's beyond our power. That seems not terribly plausible. To return to your question, this whole state-of-the-art question is relevant here, right? If indeed they can show, look, this is the best you could possibly do given current technology, well, there is no reasonable alternative design. This is the best design. But under standard logic of tort liability, that's something that they should be, that at least when the plaintiff, the burden is on the plaintiff, generally speaking, to show the reasonable alternative design, the burden would be then on them to explain why their design is better than the alternative, or at least as good as the alternative. One interesting thing is, so at least as of I think last March, if you look at OpenAI's document describing sort of at the general level, the 100-pager describing GPT, it talks about various possible kinds of harms. One thing that's striking is it doesn't even mention, nowhere does it mention the possibility of defamation or harm to reputation or libel or anything like that. So that may be a sign that maybe OpenAI is thinking about all sorts of things, including preventing the output of material that's perfectly constitutionally protected, like demeaning and hateful content, let's say. That they weren't apparently focused on thinking about a classic example of material that is harmful and unprotected, like libel. So let me just close with a few things. First, implications for other claims. False, light invasion of privacy. I won't dwell on it much, but we can talk about it later if you'd like. So related towards defamation, similar analysis. Disclosure of private facts. If there is some material that somehow was gathered into their training data, or possibly just generated, just made up, but happens to be true. Like you ask somebody something about this person, and they say, oh yes, this person has cancer. Well, it turns out that was nowhere in the training data, just somehow they hallucinated, but the hallucination was accurate. There could be similar risk of liability. Interesting questions, what do we do about false statements likely to cause physical injury, or accurate statements likely to facilitate crime? I mostly just want to flag these here for future reference. So with that, let me close my main presentation. I think then we'll have a conversation with Nate, and then we'll have plenty of time for questions.
Thank you so much. Just to get you in frame with
all right.
closer, yeah. Well, thank you. That was wonderful. Those of you online, you can put your questions in the Q&A, and they will magically appear on my device here.
You mean on your supercomputer?
Yes, right. Well, we'll see if an LLM gives you any questions by the end here. And those in the room, raise your hand if you have questions. Actually, since I'm going to adopt the format we have in the law school, which is that Mark Lemley almost always gets the first question. So even before I ask a question, I'm going to defer to Mark. Why don't you start with the first question for Eugene?
All right, thanks. So this is great fun.
And here comes a microphone for you.
Great. I guess my question has to do, it's in part a negligence question, and in part a sort of what's reasonable question, right? It does, I mean, if you know that you are propagating a falsehood and you continue to do it, that clearly satisfies the constitutional standard. But it's not obvious to me that because someone has said that the thing you said is false, that you in fact know that it's false. Lots of people would like to have truthful information about them taken off the internet, right? Well. And in the human context, right, what you've got, I think, is some sort of probably a duty to investigate at that point, right? But it's less obvious to me how that works in the AI context, particularly. So I think so. So one question is, how do we know whether the AI is negligent or has the right state of mind? You could, in fact, say, well, we're not going to ask the question at the retail level. We're only going to ask the question, is it designed to avoid too many bad consequences? But there, I think it's worth emphasizing that too many is not zero. Right, that the reasonable design presumably is going to include some amount of false statements in a software design that is all about making stuff up in the first place.
Right. So there are two things I think going on here. One is a negligence theory, and the other is the knowing falsehood theory.
let me start with the latter, as you did. So let's look at the concrete situation with Battle. Battle claims in his complaint the
I'm going to
following.
give you my, because we
Oh.
can't hear for some reason.
Huh. Is it just not turned on? Maybe that's the problem.
That was the problem.
Oh, well, all right. It's a hardware problem. So Battle says in his complaint, look, I got in touch with Microsoft and I told them that it's outputting this output based on basically Wikipedia entries or something like that, that discuss two different people and they link the two together. It isn't that, well, yes, it's true, there was a New York Times article accusing me of levying war in the US, but that's all a fiendish plot. I mean, you can imagine something like that, and at that point, you know, at some point you could say, well, we trust the New York Times and not you. No, he says, look, there's nowhere on the internet that actually makes these allegations against me. What's more, I can explain to you why this is in fact happening the way it's happening. Because there is me and there's this other guy with a similar name, and you're linking the two of us together. There's no doubt there. I mean, once a human being actually looks at that, there's no doubt that the statement, well, I mean, I suppose by sheer accident it might be correct even though nobody has ever alleged it, but there's absolutely no reason to believe that the output is actually correct. Likewise, in the Walters case, Walters says, look, you were asked to summarize this complaint. My name does not appear in this complaint. There is no, it's not like, again, it's a he said, she said, or he said, It's a he said, it said. And it said it based on nothing that any human being has ever said. So I think in that kind of situation, certainly if you call up a reporter and say, look, I can prove to you, essentially, at least at that level of proof, that what you wrote about me is false. So just stop saying these things in the future. I don't think that there'd be it would be clear at the very least the recklessness standard would be satisfied. Now, one possibility you might say, well, wait a minute. Well, so this means that OpenAI and Google are going to have human beings who are hired to do this job. Well, all right, you know, they could hire an army of moderators, Facebook and Google via YouTube and such, to moderate for various constitutionally protected speech. I would think that it's reasonable to say, yeah, you do indeed have to hire people who might spend at least 10 minutes looking into the kind of allegations that are made. And you might even say it's per se reasonable to say that if you're questioning the source, something in our training data, then we're not going to second guess that. In fact, you might even say that situation, there would be Section 230 immunity if the reason for the output is it appears somewhere in the training data. But in at least the two cases that came to court, there's really no doubt, I think. Now, the question is, what about the negligence standard? Should there be liability for negligence even in the absence of this kind of notice? And I'm inclined to say probably yes. And for that, let me just give you the session that I didn't include in my original presentation, but it's right there on this slide. Huh. Oh, it was. Can that be switched back to? Oh, sorry. Yeah, so I ran this query. Tell me whether sexual harassment by professors has been a problem at American law schools. Include 5 examples together with quotes from relevant newspaper articles. And number 4 was about Jonathan Turley, who is really a professor, not at Georgetown, but at GW. I'm not going to fault it for making that mistake. It's not defamatory. But it says, yes, he was accused of sexual harassment by a former student who made claimed he made inappropriate comments, and then provides a quote from the Washington Post, March 21st, 2018. Now, there is a professor named Jonathan Turley. There is a newspaper called the Washington Post, and there was a date, March 21st, 2018. Other than that, it's all false, including the quote, right? It's not, again, like the Washington Post said it, but it was wrong. The Washington Post never said it. It seems to me that any design that foreseeably and repeatedly, this isn't just a one-off, outputs material in quotes that actually does not appear in any source, without any signal. This is a different meaning, use of quotes. To be sure, sometimes quotes as dialogue or something like that, but there's no signal of that there. I would say that's a negligent design.
I think that's AI.
Pardon?
Well-
No, because nothing says AI has to output quotation marks, right? Nothing says that the output of LLM can't be post-processed to say anything between quotation marks. We're going to do a Google search and see if it actually seems to appear anywhere on the internet.
Can I push on that for a second and just this isn't working out, or maybe the suppose it couldn't do that. Does everything hinge on their ability to do the kind of fact checking that you're talking about?
Yes.
Suppose it didn't.
Yes.
Could there still but maybe it's just a product that is producing libel, and we say you're going to be liable for this, and the fact that you can't, it's so dangerous and so
Right.
potentially reputation harming that until we develop the technology to do real accurate fact checking on this, then you can't essentially let it out into the wild.
Got it. So I appreciate that, and there are two ways of getting to that. One is I oversimplified when I said libel can either be on a knowing or reckless falsehood theory, or for private figures as to negligence theory. There is case law that suggests that you could have strict liability for libel when it's on matters of purely private concern. I think virtually no states, as a matter of state law, actually authorize that. But you could imagine that, and I think some states do, at least at times, nod in that direction. And relatedly, every so often you do have claims that some product is just inherently so dangerous that it fails the cost-benefit analysis at the level of its creation. So one example, it's very rare to have courts accept that. I think there was like above-ground swimming pools which had very little water in them, very little depth. So the result was that people would foolishly dive into them and get paralyzed. And at least one court, I think, said, well, that is per se, that is such a dangerous thing that we're just going to say distribution of it is inherently careless because of the cost-benefit analysis. Courts are quite reluctant to do that. So, for example, there are no court cases that say fireworks. All they do is give some pleasure, and occasionally they start a really large fire, and that fails the cost-benefit analysis. Similar attempts have been made before the enactment of a federal preemption statute with regard to guns. One court accepted that and all the others did not. So I think just as a matter of the actual state of modern product liability law, the theory that you describe has some precedent, but it's very much a minority view. But you could imagine somebody saying that, look, don't put it out into the wild until you've done a little better than you have.
Samid Chakrabarti and then Daphne, just because he has the microphone. Yeah.
I just wanted to go a little bit deeper into your potential mitigation around by using post-processing.
Yeah.
And thinking a little bit more deeply about that and the implications of that. So one of the things that makes that technically so difficult here is that these are technologies that stream one token after another non-deterministically.
Right.
We don't actually know what's going to be the 10th token when they're generating the first and second token. And so that's what leads to a product design around you sort of see it generating, one token or one word at a time, and the system doesn't really know what it's going to do later on. So given that these are kind of inherently a kind of non-deterministic streaming technology, you can't easily say that there was any sort of like premeditation or intent if something objectionable comes sort of later. So given that that's something that makes this technology inherently different than many other kind of digital and internet technologies, there's no like database you can scan for accuracy and things like that. How should the law think about this differently, given that it's this non-deterministic streaming technology at its core?
Well, I think there are two things in what you're going on in what you're saying. One is there's no premeditation. And yes, it's true. The theory can't be, OpenAI is malicious in the lay sense of malicious, or what's sometimes in some cases called common law malice, hostility or ill will. It obviously doesn't have it in for Jeffrey Battle. It does not have it in for Mark Walters. So I'm not, but I don't think any of these theories of liability require a showing of premeditation. In some situations, the theory might be based on knowing or reckless falsehood simply because they were warned that they were outputting this, a particular statement, and didn't have post-processing that would preclude that. Or there could be a negligence theory, not premeditation, but that there's a reasonable alternative design. So that gets to the second point. They're generating one token at a time. Okay, let's just focus on the quotation problem, which is not the whole scope of it by any means, but it is potentially a problem. I don't think there is any law of man, God, or computer that says you have to output each token as it's generated, right? Quotations also are not usually terribly long. In the example I gave, it's what, a couple of dozen words, if that much. So you could certainly have the following design. If the software outputs an opening quotation mark, do not output anything to the user until the closing quotation mark. And then, before outputting the material between quotation marks, do a search. Search through the training data if you have the training data available. If you made the conscious design choice of not keeping the training data available, search on the internet. Not a perfect result, but at least not improbable that if you then can't find that quote in any internet searchable source, then just don't output that quote. Or use some heuristic to determine whether there's something likely to be personally defamatory. For example, the reference to a person's name or some such. Sorry about that. I thought I put it on Do Not Disturb.
Someone trying to get into your house
Someone's trying to get in my house. How sad. Sorry about that.
to defame you.
Yeah, exactly. So in any event, let me just turn off the volume. So in any event, I think that algorithm would, at least at a general level, prevent at least the libel by quote situation. Now, it's true that there may then be a little bit of a delay, that maybe if it is indeed taking 1/10 of a second per word, then it's going to, if there's a quote of 30 words, it's going to be 3-second delay before it outputs it. But again, if the alternative design causes an extra 5-second delay, I think it would remain a reasonable alternative design.
So I love this. Thank you. And I especially love it because you are starting with the elements of the claim and the defenses to the claim and walking through them. God bless you.
Because we're lawyers.
Well, anyhow. So outside the US, a lot of interesting issues have been litigated about platforms that haven't been here, mostly because of Section 230 or the DMCA. And I think some of them have some interesting lessons that go to the elements and defenses that you've walked through. So the first is about whether the output is capable of conveying a defamatory meaning.
Right.
Like, should the reader understand that this is likely could be just a hallucination?
Right.
How seriously should they take it? So your hypothetical of the picture being paired with the wrong text.
Right.
Australia says Google web search is liable in that situation. So it's it's an algorithm falsely pairing things. They said that created defamatory meaning. Germany, there was a case where an ellipses got rid of the meaning, eliminated the word not or something.
Right.
And a court, this is a long time ago, but a lower court said, nobody's going to believe that's what it means. So it's not capable of conveying a defamatory meaning. And then there's a whole batch of cases about autocomplete. You enter a business name and then it says scam. And maybe that's because lots of people have been searching for the business name. There are lots of possible reasons. So does that convey defamatory meaning? And I feel like all of those, like the answer to that in US law is rapidly evolving. What people think is the truth of an AI output is like changing by the month. And of course, for AI, differently from most platform cases, you're going to have the person like you who entered a prompt trying to get it to say something defamatory. You're not going to believe it.
Right.
And then people who see that output later on and don't know it came from an AI. So you get a lot of variation there. The other area where there's like a really rich line of high court law in the EU is about the idea that once you know something is defamatory, you should prevent it from being output going forward. So there's this case out of Austria that you would love. It's about how it's defamatory to call a politician corrupt and to say that she's a member of a fascist party. That is in fact defamatory in Austria. And what the CJEU said is Austria can order, it was Facebook in that case, to make sure nobody ever says that or an equivalent thing
Right.
going forward. And there are all these cases about like, well, is that possible? Like,
Right.
can you build a filter that will identify
Right.
that and equivalent things and not have this like footprint that basically turns any notice into kind of a right to be forgotten thing where
Right.
they're afraid to talk about you at all.
Exactly.
So I think there's both of those, like there's a lot to dig into and some of it is explored in non-US law.
Well,
That's a question.
being an American.
Do you agree?
Yeah, being an American, I am vaguely aware that there are other countries in the world. I've heard of them, but I don't know much about them. I do totally agree that this is going to be a huge issue under the laws of other countries as well, because obviously Google and Microsoft and OpenAI are subject potentially to the jurisdiction of many countries and would need to solve some of these problems with regard to that. I also agree that some of the inquiries are pretty similar. So, for example, is it capable of defamatory meaning is very much an inquiry under American law. It has indeed, as you point out, been unnecessary to ask as to search engines, let's say, and as to platforms because of Section 230. But because we're talking here about the output of the LLMs themselves, which is to say the output of the companies themselves, Section 230 drops away. And then you do have a question like can you pop up that screen again? For that, like if I were to write this, if I were to post something saying just, I read this article from the Washington Post that says this about Jonathan Turley, and give a quote and give a date, that would have defamatory meaning, and I could be liable. I actually would be immune if the Washington Post did say it, not under Section 2, maybe under Section 230, but if not under the wire service defense or some such. But if I misquote the Washington Post, if I'm quoting from memory and I'm not mentioning that, let's say, or even if I mention it but I quote really badly from memory, then in that case I would be potentially liable. Now, what if I say, I'm not sure this is right, this may be mistaken, but here's what I recall the Washington Post saying? That might go to damages, but I think that would still have defamatory meaning. So I do think that those inquiries will end up in many ways being pretty similar under the defamation laws of many other countries, in part because, as to the US, in part because the main difference, which is Section 230, is going to largely fall away.
Although you are not famously known to regularly hallucinate, to other people at least.
No, but again,
AIs are.
but hope I'm not, but humans are famously known to be inaccurate. And humans who say, I've heard the rumor that, or even, I remember reading that. Everybody knows that that process, whether it is passing on rumor or even working from memory, is an imperfect process. Nonetheless, the knowledge of that imperfection doesn't keep it from having defamatory meaning.
So I think there's a question, and building on Samid's question as to what the state of the art is really on the ability to do fact checking here. The quotes I understand the point there, but for defamation generally, that's going to be a really hard thing.
I totally
and
agree.
It's going to be even more difficult, and this is a theme that all of us who are doing work on AI here, you'll hear this at Stanford. We're going to have a whole conference on this next week when you deal with open source models.
Right.
So because so the model is out in the wild, right? And you can fine tune it, all this stuff. It can do basically the same things that ChatGPT can do.
Right.
It's not the searchability is not part of that technology, right? It's literally the way you've
Right.
got the model. And so is that what's the story with that? Are they going to be immune? Are they going to be? Because this is Llama 2, right? This is there's several of these open source models out there, and it doesn't sound like this framework would apply to them.
Right. So that's a very interesting question. I talk about it in some measure in the article, and it's complicated. But there's the possibility that somebody who designs the underlying model might be liable just for having put out this thing that is foreseeably going to be used by others in ways that are actionable. But I think there's, in many situations, and again, tort law, products liability law in particular, has dealt with similar questions before, there is the sense that you can put out some component that by itself may be very dangerous, but you're expecting it to be used together, or you could reasonably expect that it's going to be used together with some safeguards, right? So let's just take an example from, again, self-driving cars. Let's say I come up with an algorithm that recognizes a pedestrian and therefore can be used to stop the car to avoid hitting the pedestrian, but it only does it 95% of the time. I think probably if I could say, look, I'm going to put this out there, maybe even either open source or maybe even sell it, but with the understanding that the people who are going to be using it are going to take that 95% and work it into their own set of algorithms, which put together would make it 99.99995%. You don't want to prevent me from putting out kind of the incomplete solution simply because it's incomplete, because others may in fact add to it. But at some point, presumably very few people are going to go out there and query the output of just this bare bones public domain model. Some people might. But what probably is going to happen is that somebody's going to integrate it into a user-friendly, accessible product. And just as if I'm making a self-driving car, I can't say, oh, well, you know, I incorporated this public domain software. I'm just going to have this bare bones image recognition that's going to be not going to do a great job at protecting the pedestrians. I could incorporate that 95% reliable thing, but then I'd have to add enough to it, at least to match the state of the art, at least to make sure that there is no reasonable alternative design that could be safer. So I don't think that the public domain models by themselves will necessarily be reliable. But those who incorporate those models into their products, the argument would be when you incorporate it into a product that is going to be routinely used by tens of millions of users, you need to put in at least a reasonable amount of safety features into it.
But the reasonability, so I think the incorporation of Google search alongside Bard or Bing search alongside GPT, that's not like a trivial, that's not so easy to do, right? And so, and if you look at like the open source image tools, I mean, they really are out there in the wild. It's like, and people are then using them on their laptops to create all kinds of stuff. And so it seems to me like that the open source model is going to, there's going to be the same stuff that could be produced by an open source model that would be produced by, say, OpenAI. One's going to be liable, one's not going to be, because of what the decision to make it open source is going to assume that the reasonable technological alternatives that you could have put in there are just cost prohibitive or very difficult to do. And so that the closed source models are going to be liable, whereas the open source are not.
Right, so it's an interesting question. And again, I don't want to overclaim the degree to which the answer is legally determined. But at the very least, one inquiry that arises as to reasonableness is the resources of the defendant. So just to give an example in libel law, I oversimplify here, but if I'm just a casual writer, who's not a professional writer, and I get certain information, the amount of fact-checking that I would be expected to do, assuming I'm in a negligence regime and not actual malice regime, may be relatively modest because my ability is relatively modest. That's actually, on the other hand, a newspaper that has time to look into it and the resources to look into it, the standard of care may be somewhat higher. And as it happens, the false statement by the newspaper, if it is false, is going to be much more damaging, in part because people trust newspapers more, precisely because they have the resources to do the fact-checking. So it certainly may well be the case that if it's just a question of what is reasonable to ask of somebody some researcher who just puts out some public domain software, mostly so that other people can build on it, that standard of care may end up being lower than the standard of care for a company that incorporates this into a commercially used search engine that's going to be used by billions of people.
Great. Well, I think we've run out of time, so please join me in thanking Professor Eugene Volokh. And I'll say for next week, we're having our pattern of law professors, which we haven't had. We're getting a surplus. So I think next week is Professor Spencer Overton from GW. Oh no, Britton. I'm sorry. Another budding law professor, Britton Heller, who's going to be talking about a report that we're issuing on policy related to virtual reality, and following her is Spencer Overton from GW, who's going to talk about AI and multiracial democracy. So